down the elevator. It's the second, or the very last over on the left. So I'll be up there in a minute. Okay.
Yeah. Here you go.
Leaving a mess where they go.
Oh, yeah, there you
Is
go.
Carl up here?
Who?
Carl?
I don't remember. Yes.
All right, so Mr. McKenzie, I see you, Miss Williams. All right, let's see, did I get you sick too?
No.
Oh. All right, Mr. Morris, you want to come on up? That's what I'll do. Just come on up to the podium. So this is in the matter of the people of the state of Michigan versus Harold Joseph Morse, file number 20-19771FH. Mr. Morse is present in person. So Mr. Morse, we're here this morning on a request and summons for probation violation. Looks like restitution was ordered in the amount of $11,019.72. You have a balance owed of $9,900.95. And you're due to discharge on May 8th of 2025. So, Mr. Morris, you're obviously on probation for attempted identity theft, which carries a maximum penalty of, I think it's 2.5 years. So you do have a right to have an attorney represent you on this case. If you can't afford to hire one, we can appoint you one. Would you like an attorney appointed to represent you? Yeah, speak up for me, Harold.
Yes, I got something to show you. I'm gonna pay it off tomorrow.
You're gonna pay off $11,000 tomorrow?
This is legit, so.
Okay, so I can't hear your case today anyway, and I'm gonna have to adjourn it out to next week. So, Ms. Adams, could I get a date for Mr. Morse next week? It doesn't have to be Wednesday.
Okay. How much time?
10 minutes. A day Rhonda's here would be nice.
I would say next Wednesday is probably best.
All right, can I get a notice of hearing for Mr. Morse?
Okay.
So next Wednesday will be May 7. So I'm going to adjourn to May 7 at 8:30 in the morning or 8:15 in the morning. And just have a seat right behind you and we'll get you a notice of hearing. Do you know how to, I'm not gonna come down there and look at it. You're gonna call Miss Underwood. Miss Adams, could you write the public defender's office and Rhonda's name on that notice of hearing?
Okay.
Call her and explain what's going on, all right? And whatever that is, you can show to Miss Holly too.
Yeah.
Okay. All right, have a seat right behind you.
I think that's all I have with you, Judge.
Okay, thanks, Miss Holly.
Yep.
All right. So Walden's not in custody. Kayla Walden, the matter of the people from the state of Michigan versus Kayla Ray Walden, file number 25-22101FH. This is the date and time set for a request and summons for probation violation. Ms. Walden has failed to appear. I'm going to issue a bench warrant for her arrest, set bond in the amount of $25,000 cash. Unless she's one of these cell phones, I don't know. I have somebody on an iPhone. I'm going to send you a request to unmute your device. Could you please unmute your device and let me, what's your name?
Emmanuel Simmons.
Oh, good morning, Mr. Simmons. Stay with us for just a minute. All right, and I'm going to issue a bench warrant for Ms. Walden and set bond in the amount of $25,000 cash.
Thank you, Your Honor.
Thank you, Ms. Underwood. All right, Mr. Simmons, that's all I have with Mr. Goldstein, so why don't I take you next? In the matter of the people of the state of Michigan versus Emmanuel Simmons, we have 1, 2, 3 files, 24-21830 FH and 24-22051 FH and 24-22052 FH. I have David Goldstein appearing on behalf of Mr. Simmons and Isaac Sneed appearing on behalf of the people. Mr. Simmons and Mr. Goldstein, I have a note dated April 29th from Darren Coast, our pretrial services coordinator, who states that Mr. Simmons continues to do a good job with his testing. He does not miss. He's only positive for THC and has a medical marijuana card. So, Mr. Goldstein, how would you like to proceed today on behalf of Mr. Simmons?
Your Honor, I'm going to ask that these matters be set for trial. I suspect the trial date's going to be a ways out, which leaves Mr. Sneed and I plenty of time to continue discussing possible resolution.
All right, so would these be tried together or would they be?
They're separate incidents as far as I can tell, Your Honor.
Okay, so we would start with trial on.
Your Honor, if I could propose, if we could set the trial on the file ending 30 FH, that's my case. The other two are Mr. McCready's. And so.
Okay, that's the oldest one anyway, so that's the one I would set for trial first.
Is that the 7/16/24, Isaac?
No, 21830.
No, I'm
Right,
looking at the date. I'm looking at the date, Your Honor.
Oh, I'm looking at file numbers. I'm sorry.
Yeah, one moment I can look up the date. Yeah, it's Valentine's Day of 2024.
Yeah, okay. I never get this. When there's multiple files, I get the numbers mixed up, so.
So, Mr. Sneed, we would do 21830 first.
Yes, please.
Okay. Hold on 1 second. All right. That is assault with intent and ag domestic violence. So how many days do you think you need for trial, Mr. Goldstein?
Believe 2, Your Honor.
Does that include jury deliberations?
Yes, Your Honor.
Mr. Sneed?
I would agree with that, Your Honor.
All right. Yeah, so that's a good thing. Tuesday, September 2nd.
Just a moment, Your Honor. Oh, I'm looking at the wrong month. Hang on, Your Honor. I already have a jury trial scheduled for that week, Your Honor. I can do the next week.
Yeah, your retirement's going really well, Mr. Goldstein.
I'm trying, Your Honor.
How about Wednesday, September 10?
That would work.
Mr. Sneed?
Yes, thank you, Your Honor.
All right.
And then my suggestion, Your Honor, would be to put the other 2 cases on for pretrial that morning.
Yep, they will, and then I'll have them all set for the final pretrial. So the Wednesday trial date would start at 10:30 a.m. and then it would be a 9 a.m. start date on Thursday and into Friday, if we go that far. And then let's see, so do September 10. I want to do a final pretrial on. Let's see, you're in trial. Would you be able to do a pretrial on September 3rd or no?
Probably not, Your Honor. It's going to be an ugly trial, so.
August 27th.
I'm going to be just a second. August 27th. Yeah, that should work.
All right, I'll set a final pretrial for all files on August 27 at 8:30 in the morning. That'll be the motion deadline, just to make it clean. And I require all jury instructions and voir dire questions to be provided to the court on, let me see, August 20th, just so we have time to review them for the final pretrial. And I think that is it. So I filled out a scheduling order and we will get a copy of that out. Keep up with your bond conditions, Mr. Simmons, you're doing a good job. And then I will see you all back for those dates. Obviously, if you reach a resolution, Mr. Goldstein, I'm always happy to take it on a day that's not a Wednesday.
Thank you, Your Honor.
All right, thank you all. Your bond's continued, sir. Your client here.
The client is, but I believe we're waiting on the prosecutor.
Who's your prosecutor?
It's either gonna be Ms. Wise or, was Mr. Hart.
Who?
It was Doug, but
I
it's,
have a hard time.
yeah, I don't think he's gonna be here for this.
He's here, but
Okay.
Mr. Hartung, are you
There she
on?
is. There's Ms. Wise.
Are you on Caitlin Weiss Robertson?
Ms. Wise is going to handle that this morning, Your Honor.
Right. And where's your client?
She is outside.
You can, okay, bring her in. Thank you. All right. Hey, this is Judge Anzalone. I'm ready for like everybody on my list.
Okay, tell you what, I will start with Howard.
No, Powers is set at 10 o'clock today.
Oh.
So the rest of them, okay, thank you.
All right, thanks.
Bye.
Oh, yeah, I get it.
All right, Mr. Glazier, I'm gonna go ahead and mute you. All right, okay, Mr. McKenzie, let's see. I'll take care of you while they're having a discussion here. So in the matter of the people of the state of Michigan versus Casey McKenzie, file number 24-21789FH. Mr. McKenzie, we are here for a pretrial on your file. You are currently pro per. Did you request court appointed counsel, Mr. McKenzie?
Court appointed.
All right, so did you, you have Mr. Fry, correct?
Yes.
Okay, so we are waiting on Mr. Fry. And so if you don't mind, just be patient with us while we wait for him to get here, all right?
All right, thank you.
All right, thank you. And are you ready on Roberson now?
We are, Your Honor.
Okay, let me find her file. All right, this is in the matter of the people of the state of Michigan versus Caitlin Elaine Wise Roberson. Is it Roberson or Roberson? Roberson. All right, you can stand up here next to Mr. Margolis. I have Larry Margolis appearing on behalf of Ms. Wise Roberson, and I have Jacqueline Wise appearing on behalf of people. I'm assuming there's no relation. No. Okay. And so this is a date and time set for a pretrial. So Mr. Margolis, how would you like to proceed today?
Thank you, Judge. Nice seeing you. Good morning.
Good to see you too.
I'm here on behalf of Ms. Caitlin Wise Roberson. I've spoken at length with the office of the prosecutor, first with Mr. Hartung and now with Ms. Wise, and we are prepared to put a plea on the record.
All right. And so what is the plea offer?
So we will be pleading to count one. I'll let Ms. Wise first state the recitation on her understanding, and then I will confirm if that's okay with Your Honor.
Ms. Wise?
Yes, Your Honor. I believe Ms. Roberson will be pleading guilty as charged. There is a restitution amount. We discussed that we believe there was an amount embezzled of approximately 241,000. However, we would both reserve the right to have a restitution hearing once that PSI is done. We would be requesting no upfront jail to allow Ms. Roberson the opportunity to pay those funds back. We would be asking for probation for a term of 5 years, again, to pay those funds back. Upon successful completion of payment of that restitution to Glove Enterprises, the people would move to then reduce the felony to a misdemeanor. If that is successfully completed and there are no new cases during that 5-year probation and she successfully completes that. Am I missing anything, Mr. Margolis?
I don't believe so. Is that your understanding? That's our understanding. We're prepared to move forward. We have brought the first payment today, the down payment of $10,000 certified funds that I have provided to the dutiful prosecutor.
And I am in receipt of those funds, Your Honor.
You're gonna keep those, right? You're not gonna give them to me? Thank you. Okay, all right. Yes.
Where is
Anybody
this on the
please?
docket?
It was handwritten in, I apologize. So your docket might have it on the bottom of page 1.
Okay,
So do you want the file number?
please.
24-22022 FH, and her name is Caitlin with 2 I's, right? And Wise hyphenated Roberson. Okay. So, you're gonna have to bear with me because I've been really sick, so I can't breathe. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, so you're gonna need to speak a little bit louder.
Yes, Your Honor.
Okay, so, and you go by Weiss Roberson or?
Weiss
Yes.
Roberson.
Okay, you can put your hand down. So you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, embezzlement, $100,000 or more, which carries a maximum a penalty of up to 20 years in prison and or a fine up to $50,000, or 3 times the amount embezzled, which is ever greater? Do you understand that?
Yes, Your Honor.
All right, and there is an agreement that restitution is thought to be around 241,000. Each party has a right to have a hearing on the amount. There will be no upfront jail, 5 years probation, and
So sorry.
if it's paid in full by the end of probation, this would be reduced to a misdemeanor. Do you understand that?
Yes, Your Honor.
Now, you understand if you were to violate probation or not make payments, you could potentially go to jail or prison. Do you understand that?
Yes.
Okay. Now, are you satisfied with Mr. Margolis as your attorney and the advice that he's given you?
Yes, Your Honor.
All right. And other than that, neither the prosecutor, the defendant, or anyone on the defendant's behalf has made or discussed any other possible sentence with the court. Mr. Margolis?
That's correct.
That's correct.
This way, okay. And is that correct as far as you're aware?
Yes.
All right. If a guilty plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. You have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right. So, ma'am, how do you wish to plead to the charge that on or about March 27 of 2024 in the city of Tecumseh in the county of Lenawee, that you did commit the offense of embezzlement, 100,000 or more, guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
I understand.
Okay, sure you want me to go over that again? You got it?
I got it.
Okay. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Margolis?
No, Judge.
And Ms. Weiss?
No, Your Honor, just for clarification, though, the date should have been from sometime in 2020 through 2024. So I apologize for that. It was a date.
Do we know those dates?
No, I don't. Do you have that in front of you? I can,
It was early 2020 through early first quarter of 2020.
I just now realized that the date was wrong, so I'll pull that up if you want, and then we'll go over the factual basis. I'll do it. Thank you.
All right.
On or about February 2020 through February of 2024.
Yes, Your Honor, thank you.
So Ms. Weiss Roberson, would you agree with that?
Yes. I agree.
Okay. Let's see, has your attorney promised you, other than the agreement that was placed on the record, any particular sentence or estimated what the sentence will be in terms of fines and costs and probation terms?
No.
Okay. Is it your own choice to plead guilty?
Yes.
All right. So during February of 2020 through February of 2024, is that what we're going with?
Yes.
All right. Were you employed at, is it Glove Enterprises?
Yes.
And what was your position there?
Controller and HR manager.
So, did you have, I don't know, Ms. Weiss or Mr. Margolis, you want to blend here on this?
Did you, sure, I will, Judge, if that's okay. In that capacity as controller, did you have access to the checkbook?
Yes.
Did you have access, were you able to write those checks
Yes.
for the company?
Yes.
And did you write checks to yourself?
Yes.
And were you authorized to write certain checks to yourself?
No.
And you did?
Yes.
Okay. And it was your intent to defraud the company of that monies? You were converting it to your own use, were you not?
Yes.
All right, so that could be defrauding the company?
Yes.
Ms. Weiss, any follow-up?
And it had a value of at least over $100,000, correct?
Yes.
You understand that you and your attorney have a right to a restitution hearing if you want one?
Yes.
Okay. Are you satisfied, Ms. Weiss?
Yes, Your Honor.
We are, Judge.
All right, I accept, has the court complied with MCR 6.302 B, C, and D? Mr. Margolis?
You have, Judge.
Ms. Weiss?
Yes, Your Honor.
All right, and I accept the plea. It's been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew agreement that was placed upon the record. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Margolis, sentencing can be done in person or via Zoom unless the prosecutor has a preference. Are you available June 12th at 8:15?
I believe so. If not, I will let the court know.
I mean, yeah, I can wait.
No, it sounds like I'm in town. That'd be the only reason I wouldn't. That's fine, Judge. If something were to change, I'll let the court know.
Oh, of course, we can. So, do you want to appear in person or via Zoom?
As of now, let's appear in person.
In person, okay. All right, so that's going to be at 8:15 in the morning. So this morning, Mr. Margolis will walk you across the hall to the probation department. Check in there. They're going to give you instructions on meeting with them. When you meet with them for the pre-sentence report, be truthful with them about your background, the events that occurred. They'll prepare a report. We will send that to Mr. Margolis. He'll review that with you before sentencing, and we will see you back on June 12th at 8:15 in the morning in person, okay? Anything else, Ms. Weiss?
No, Your Honor.
Mr.
Thank you.
Margolis?
restitution hearing would be after.
Yeah, if you dispute it, we can always adjourn the sentencing to do the restitution hearing if we need to. It's not a problem.
Thank you.
Thanks,
All right,
Judge.
thank you both, and just step across the hall, please.
Always a pleasure.
Always a pleasure, thank you.
Joanne?
I think I saw you at a swearing in Washtenaw, I thought,
Oh, yeah?
for Judge,
Oh, Hamud or?
Hamud, yeah.
Nice. Get to say hello.
All right, so.
Feel better.
Let's see, I've got Mr. McKenzie waiting on Mr. Fry. And I got someone who's waiting on that one. And I have someone from Huron Valley. And it, let's see, it's not QC. So who do I have at West Huron Valley?
Shannon Foley.
All right, there you are. That's Mr. Glazier, Mr. Glazier.
Yes, Your Honor.
All right, in the matter of the people of the state of Michigan versus Shannon Marie Foley, file number 25-22138FH. I have John Glazier appearing on behalf of Ms. Foley, and I have, I'm gonna go with Isaac Steen on behalf of the people. There we go. I got Isaac Steen appearing on behalf of the people. This is date time set for a pre-trial conference. Mr. Glazier, how would you like to proceed today?
I need to speak with the prosecutor that's handling this, Your Honor.
Well, we don't do that on Wednesday mornings. You can text them, you can call them. I'm not giving breakout rooms, so.
I sent a letter over a week ago and I haven't heard any response, Your Honor.
All right, Mr. Sneed, who's the prosecutor?
Mr. McCready, Your Honor.
All right, you got to reach out, give him a call. I don't have him here today. So how would you like to proceed? I mean,
I guess I'd like to.
you can call
adjourn
him and I can go back to her in a minute.
That's fine, Your Honor.
Okay. Mr. Roscoe. All right. All right. I do have Mr. Let me see. I have Michael Dagger Margosian. All right, Mr. Oliveras. All right, in the matter of the people of the state of Michigan versus Castro Cash Oliveras, file number 24-21891 FH and 24-21892 FC. I have Isaac Sneed appearing on behalf of the people, Michael Dagger Margosian appearing on behalf of Mr. Oliveras, who is joining us from the Lenawee County Jail. So Mr. Dagger Margosian, how would you like to proceed on behalf of Mr. Oliveras?
Well, Your Honor, this is the time and date set for a final pretrial. We had adjourned this case last week because we were waiting to see if district court would be done with preparing the preliminary exam. I still don't have that preliminary exam. I don't think that the people do either. I talked with Mr. McCready this morning. I can't move forward with it. I mean, this is set for a bench trial in a few weeks. I can't move forward with that without that exam. So
yeah, and that's only 2 weeks. That doesn't give me enough time hardly at all. Would you agree, Mr. Sneed?
No, I think a week would be enough to review an exam transcript that one participated in, but that's just my opinion. Could we?
We don't have it, Mr. Sneed. We don't have it. That's
Yeah, I understand. Could we possibly pass this, and can I contact Mr. McCready to appear?
Yeah.
Thanks, sir.
All right, so Mr. Oliveras, we're just gonna hang tight for a minute. Okay, so hang with us for a minute, Mr. Oliveras. Who do I have in jail Zoom 3?
Ricardo Garcia.
Oh, Mr. Garcia, Sam Malaro. I do not have Christina Edmonds. Do you want me to call that case, Ms. Underwood?
Yes, you can call that case, Your Honor.
In the matter of the people of the state of Michigan versus Christina Edmonds, file number 24-21983FH. I have Rhonda Underwood appearing on behalf of Ms. Edmonds. And this is a probation violation. For some reason, she came across my radar. Did she get picked up for something last week? Is she at the jail?
Your Honor, I understand that she is not at the jail. I talked to Ms. Walsh yesterday. She does have a new OWI, so maybe it did get in the jail.
She got picked up on that, yeah. All right, well, I saw she got arrested on an OWI, that's what it was. She's failed to appear. What does she owe on her file, Ms. Walsh? You're muted, Ms. Walsh.
I'm sorry, what was the question?
What's the balance owed on her file?
I don't know. She just got sentenced on April 11th.
Okay.
I
No,
have her
I'm
on
all
the
right.
phone. You know, you had court this morning, Miss Edmonds.
For what?
For your violation. It got adjourned today.
What? I thought I would go back to 5-1.
No, I have you on the phone.
I muted you, Ms. Walsh, just in case. I'm gonna mute you. All right, Mr. Dagger Margosian, while we're waiting, can you tell her just to call in, Ms. Walsh, zoom in? All right, Mr. Dagger Margosian, I have Mr. McCready now on Castro Oliveras. So Mr. Dagger Margosian and Mr. Sneed. So Mr. McCready, evidently preliminary exam transcript was ordered in this. It has still not been received. I will follow up on that today to find out why. We are 2 weeks from trial, and Mr. Dagger Margosian's concerned that we don't know when we'll get it. It could be next week, and we do have a bench trial on the docket. I can set it over to next week for another pre-trial, or we can set the trial date out another week or two. So Mr. Dagger Margosian and Mr. McCready, how would you like to proceed?
For me personally, I'd like to just set it out just 1 week, keep our trial date on the books and see where we are with the transcript.
That's fine. I agree.
Okay. So Mr. Oliveras, I'm gonna set this over to May 7th already. So I don't know how that happened so fast. So May 7 at 8:30 in the morning. And Mr. Dagger Margosian, can you do this in order to adjourn?
I will do so, Your Honor. Thank you.
All right, thank you very much. And Mr. McCready, you can sign your name with permission.
That's fine.
All right, so Mr. Oliveras, I will see you back in a week, and hopefully we'll find out what's going on with the transcript, all right?
Thank you.
All right, thank you. Okay, Mr. Garcia. Mr. McCready, will you call Mr. Glazier or vice versa? I don't give breakout.
I talked to him, Your Honor.
Okay, good. So that's Foley, right?
That's correct, Your Honor.
Okay, so we're back on the record in the matter of Foley. So I originally had a plea agreement to plead to a possession second, run concurrent, maybe. So Mr. Glazier, Mr. McCready, how do we want to proceed today?
You have for a possession second offense?
Well, that's what I had. What is the plea, Mr. McCready?
So initially that was what we were offering, and Mr. Glazier made a counter proposal. And I emailed him back to say, we don't have to do possession second, but we have to do, if we do just the possession, then it's got to be with the habitual fourth offender notice. So those are the two options. I would take either one.
I'm sorry, Mr. McCready, and I don't know which room. I'm getting a lot of background noise, so I kind of missed that. So what is the plea offer now?
Well, I've made two alternatives. Both of them start with possession of meth. She can do possession second offense, possession of meth, second, offense, or she can do possession of meth with no second offense sup, but with the habitual fourth notice.
So one is
But-
life and one is 40 years?
Also, we would run it concurrent with her current sentence.
Okay. Mr. Glazier? Because the
I
guidelines
guess-
double on a second offense, right?
I believe that's correct.
Okay. Mr. Glazier?
I guess at this point, Your Honor, we'll ask to set it for trial.
Okay. All right. Yeah, that's not much of a. All right, let me see. One day. Let's see. 1 day trial. Let's see. So, Mr. Glazier, I don't know, are you available July 16 and 17 if it runs over?
Yeah, I'd be available.
Mr. McCready?
I'm available the 16th, but not the 17th. I'm off for a week starting the 17th.
We do the 15th.
15, 16 would be fine.
Mr. Glazier?
That's fine, Your Honor.
Can I talk to my lawyer in a breakout room by chance?
Yeah. So hold on 1 minute, let me get this done. All right, 17. I think it'll be a 1 day trial, but sometimes it goes over. So it'd be 7:15 at 9 o'clock. I'm going to set a final pretrial for July 9. Everybody here, July 9?
That's fine.
That's fine, Your Honor.
All right, juror questions and voir dire questions will be due by June 25. And final motion date will be July 9th. Oh, July 9. All right, and I have filled out a scheduling order and I am going to sign that.
Did you mention the motion deadline?
Yeah. Motion deadline is July 9th.
Okay, thank you.
The same as the pretrial.
Okay, thank you.
And today is April 30th. Yes. All right, so I filled out a scheduling order. I'll get a copy of that out. Ms. Foley, you want a breakout room with your attorney, so.
Your Honor, before we do that, could I check and make sure she has a cash bond on this?
Say, I can't hear you, Mr. Glazier. Say it again.
I wanted to know if she had a cash bond on this case.
I don't, let me see. Let's figure out. I don't know where I'm getting all that noise from. Oh, okay. Legal mobilization, arraignment. Estate, bail, warrant. Well, I don't, I'm looking at the district court paperwork to see, and I'm not seeing a lot of paperwork on this. Bond recommendation. Looks like she got a 5,000 cash surety.
All right, thank you, Your Honor. Yeah, I'll speak with her.
Okay, so let me open up a breakout room. And Ms. Foley, when you're done, unless you're coming back in for any reason, you can just disconnect, all right?
Okay, thank you.
There you go. Go ahead and join that breakout room. All right. Yep. All right, Casey McKenzie, I am still waiting on Brian Fry. He's probably down in the other courtroom. Miss Adams, can you text to let him know we're ready whenever he is?
Judge, I did a little while ago. He was just doing a plea and was gonna come to your court.
Okay. All right.
Like that. Yeah. Okay, so that in and of itself is going to preclude your ability to take care of children. You know, I don't know where you're at.
All right, so Mr. McKenzie, I am really sorry. I'm going to mute you and then we'll figure out how to unmute you in a moment, all right? Okay. Hopefully we'll be able to fully. I got Christina Edmonds, Miss Underwood. I knew Miss Edmonds usually always showed up. Miss Williams, I have not forgot about you.
She's calling in, Your Honor.
Yep, I got her. She's right there. Miss Edmonds, you want to go ahead and unmute your device?
Yeah, okay, here we go. I am so sorry.
You know, Miss Edmonds, you boys showed up for court, so I was surprised you weren't here. So this is in the matter of the people of the state of Michigan versus Christina Mia Edmonds. And this is file number 24-21983FH. I have Rhonda Underwood appearing on behalf of Miss Edmonds. This is the date and time set for a probation violation hearing. We are aware that Miss Edmonds was arrested for an OWI, which could result in another violation of probation if she is found guilty. So Miss Underwood, how would you like to proceed today?
Your Honor, I discussed this with Ms. Walsh yesterday, and I believe putting this out for a couple of weeks would be the best thing to do in this matter.
All right, so Ms. Edmonds, I am going to adjourn this out to May 21 at 8:30 in the or 8:15 in the morning. So May 21 at 8:15 in the morning. Write that down. Same Zoom number, and we will see you back on that time. And make sure you just make all your district court dates and your report dates. All right.
I will. Thank you.
Great. Thank you,
Judge,
Ms.
I have
Edmonds.
I have training that day. Can we make it the week after, possibly?
Okay, so yeah, I'm never going to deny a probation officer moving it out further. So May 28th at 8:15 in the morning, we'll do the notice because it's a violation of probation. Thank you.
Okay,
Okay.
thank you.
Thank you. All right. So Adam Steers in the courtroom? No,
Yes,
he's
Your
in
Honor.
jail. Oh, Mr. Steers, is that you?
Yep.
Okay. We'll grab his file. All right. Let's see, Miss Williams, I believe this is one of your files. So this is in the matter of the people of the state of Michigan versus Adam Christopher Steers, file number 25-22236FH. I have Rhonda Underwood appearing on behalf of Mr. Steers. And Miss Williams, can I get your full name and your P number, please?
Yes, good morning. Assistant Attorney General Clarissa Williams on behalf of the people, P84270.
Welcome back. So this is arraignment in this matter, I believe, Miss Underwood. So you waived the reading of the felony information?
We would waive the reading of the information, Your Honor. Acknowledge its receipt and the receipt of the request for discovery and enter a not guilty plea on Mr. Steers' behalf right now. But Your Honor, if I could, and we'd like a very quick pretrial, Your Honor. Very quick.
May 21.
That's fine.
All right. Are you available that day, Miss Williams?
Yes, Your Honor. May 21st at what time?
8:30, ma'am.
Thank you.
All right, so I will enter a plea of not guilty on behalf of Mr. Steers and set it for pretrial, May 21 at 8:30 in the morning. Because it's arraignment, my staff will do the notice of hearing. Anything else, Ms. Underwood?
I would like a breakout with Ms. Williams, Your Honor. I believe
I
we
have
also,
one more.
I believe
We have
we
one
also
more.
have another case, but I wanted to get an update on his payments because is Mr.
Okay, can I finish this case first? So hold on. So, all right, so we're good then on Mr. Steers. Mr. Steers, you're all set. We'll see you back May 21 at 8:30 and your bond's continued, all right?
All right, thank you, Your Honor.
Thank you. Let me get the other file. Hernandez, Ramirez. So, you guys can chat if you want an update. I'm not giving breakout rooms for AGs, prosecutors, and attorneys. So Oscar Hernandez Ramirez. Oh, you're right there. Come on up. He's present in person. You know, you can appear via Zoom if you need to, right? Yeah. Okay. So this is in the matter of the people of the state of Michigan versus Oscar Hernandez Ramirez. Just because you look like you were supposed to be at work. Yeah, so you can Zoom from your vehicle if you want. You don't have to come in person. Okay. Okay, I don't want you to miss work. 24-219-65FH. This is a date and time set for pretrial. Again, I have Ms. Williams appearing on behalf of the AG's office and Ms. Underwood on behalf of the defendant. So Ms. Underwood, how would you like to proceed today?
First of all, I apologize, Your Honor, because since I don't know which AG is appearing, I can't check. And so that was why the breakout was requested. But, Your Honor, I would like to ask for probably a 90-day adjournment in this matter. Mr. Ramirez Hernandez has been excellent at making his payments, and I don't suspect that has stopped. In addition, he has appeared this morning, and he's kind of been a really good example since he made his bond.
All right, Ms. Williams, do you want to verify that?
Yes, I have verified. He has been paying consistently, although this month, I'm not sure why it was a couple dollars short than the monthly obligation amount, but he has been paying consistently. I would agree with that. I guess I would just need to know or clarify from Ms. Underwood what we're seeking with the adjournment. Are you trying to get a reduction in?
We're trying to work towards some sort of delay plea.
Oh, okay. I have no objection to that.
All right, well, where do you work at?
Yeah.
Oh, okay. So, yeah. Do you need an interpreter?
No, I'm good.
You good? All right. So Miss Underwood or Miss Adams, can I get a pretrial notice for June 18? He's going to be hitting his busy season now, so he might be able to pay extra. And then Miss Adams, could I get a Zoom instruction for him as well? So we will set this for June 19. And I'll do the notice just because he's here and I want to make sure he gets one when he leaves at 8:30 in the morning. And if you Zoom, you can just go sit in the car and call in. All right. That way you don't miss work.
Mr. Hernandez Ramirez, could you contact my office with a good phone number? We do not have one for you.
John, wanna
I can do
break
that.
out with me? No. Mr. Steers, you're all set.
Yeah.
Okay. You're all set.
All right, so the 21st.
Yes, sir. I think
Okay,
so.
thank you.
So have a seat right behind you. Have a seat, and then we'll get you a notice. All right. Thank you.
Thank you.
All right, and I believe Miss Williams, that gets you on your way. Thank you.
Thank you. Bye.
Okay, so
I think that's everything for me, Your Honor. Or
Heimerdinger.
Hmm?
So you have a Heimerdinger,
Oh,
Heimerdinger.
yeah. Is she on the screen from Jackson?
No. So let me pull the file. I think I already set a warrant to catch her, but this is in the matter of the people of the state of Michigan versus Jamie Marie Heimerdinger, file number 21-204-07FH. Let's see, April 2nd. I still have a warrant for her so that we get a hold, but I don't see that she has appeared. Do we have any contact with Jackson for today?
Thank you.
All right, thank you. All right, let us just check, but I've already issued a warrant for her. She has not appeared, so I believe you're all set.
She appeared the last time from Jackson.
I know, but I still left a warrant in for a holder, so I don't lose her. All right, Miss Adams is gonna check if we still do. Okay, Mr. Fry, I have
Judge.
Casey. Yes.
Yes, they responded that they would have her available.
So she's not available yet, but if we get her, I'll call you.
Okay, thank you.
All right, thanks, Miss Underwood. All right, Mr. McKenzie, I'm gonna see if I didn't screw that up by, I'm asking for an unmute. Oh, yes, you can do it. Perfect. Maybe. I'm sorry. Will you knock on the door and tell them somehow we got to unmute? Yep, I was getting a lot of background noise, Mr. Fry. All right, so, I have Ricardo Garcia, right?
Yes, ma'am.
And then who else do I have from the jail?
Joseph Brown.
Brown, all right.
Did it unmute?
Oh, it unmuted. Thank you. All right. So I'm in the matter of the people of the state of Michigan versus Casey McKenzie, file number 24-21789FH. I have Mr. Fry appearing on behalf of Mr. McKenzie and Mr. McCready appearing on behalf of the people. This is the date time set for a pretrial conference. Mr. Fry, how would you like to proceed?
Your Honor, if the court's able, can I have a breakout room with Mr. McKenzie?
Yeah. All right. Yep, I'm going to open up a breakout room with JCS hearing 3 and Mr. Fry. All right, go ahead and join that room. All right, and Mr. Garcia, Mr. Malaro. Ricardo Garcia is a probation violation.
Probation judge and an arraignment.
Yep, so in the matter of the people of the state of Michigan versus Ricardo Anthony Garcia, I have 2 files set for probation violation 21-20525FH and 21-20575FC. I have 2 files set for arraignment today, 25-22232FH and 25-22233FH. I have Salvatore Malaro appearing on all of these files, and I have Isaac Sneed appearing on behalf of the people. So, he's on parole and probation, I think. He's on parole with Mr. Face and probation with Ms. Teskey. So, Mr. Malaro, do you waive the reading of the information on the arraignment files?
Yes, Judge, at this time, we'd waive reading of the information, waive any defects as to time and place of service. Mr. Garcia would stand mute as to all of the counts and the habitual offender notices in both files. We would ask that the court enter a not guilty plea. We'd further acknowledge receipt of the witness list and ask that these matters be set for pretrial. And we'd also ask that the violations of probations also be set for pretrial at the same time. Judge, we're close to having this resolved. We're just waiting on, I think Mr. Garcia was referred for recovery court, waiting on that decision.
May 21.
That's fine. And I did talk to Mr. Face. I think that part of his case is kind of resolvable.
What do you need?
DQ file or send.
Oh, yeah, it was. Who is it?
There, Evans, CART Evans.
Okay.
Should be the court.
Okay, Joanne needs to file next then. Am I doing it today?
Yeah.
Oh, yeah, give it to Joanne first. Thank you, Serge.
Yes, ma'am.
All right, so I'm gonna enter a plea of not guilty on all the files. I'm gonna set a pretrial conference for May 21 at 8:30 in the morning. And is there anything else that's continued? Anything else, Mr. Millar or Mr. Sneed or Ms. Walsh?
No, thank you.
Not at this
All
time,
right.
Judge. Thank you.
All right, Mr. Garcia, thank you very much. We'll see you back on May 21. And Mr. Milaro, we do the notices on all those, so you don't have to do anything today. Thank you.
Thank you, Judge.
All right, so Brian's talking to Casey McKenzie, and I have Joseph Brown. Miss Adams, I have a PPO file that's being added today. If you need the information. right.
I guess I can get the file number just in case.
20, I already gave it to Miss Spade, 25-52438 PP.
Thank you.
So Mr. Brown, your attorney is Mr. Milaro. So in the matter of the people of the state of Michigan versus Joseph Brian Brown, file number 24-22087FH. Salvatore, Douglas Hartung appearing on behalf of the people, and Salvatore Milaro appearing on behalf of Mr. Brown. This is the date and time set for a pretrial conference. Mr. Milaro, how would you like to proceed? I can't hear you.
Can you hear me now, Judge?
Yeah, oh yeah, I can hear you now.
Your Honor, I would ask to adjourn this one time. I need to sit down with Mr. Hartung and see if this matter can be resolved short of trial.
Your Honor,
Right,
I have no objection to that. I do want to indicate on the record, this is exactly the position of the defense at the last pretrial. So I'm happy to sit down with Sam anytime he wants to talk about it.
all right, May 14 at 8:30 in the morning.
That's fine, Judge.
Hold on one second, please. Is it possible to do it the following week?
Yep, May 21 at 8:30 in the morning.
Does that work, Mr. Milaro?
That works, Judge. And Mr. Hartung.
Thank you.
All right, and Mr. Milaro, you do this in order to adjourn. Will you do this in order to adjourn?
Yes, I will do that for you, Judge.
You can find my
And
name if you'd like to.
Obviously, if there's a resolution sooner, just let us know and I'll bring them in. All right?
Thank you.
All right, Mr. Brown, I'll see you back then, if not sooner, okay?
Yes, ma'am.
All right, so, let's see. Are you a defendant? What's your last name? Evans? Are you that new PPO file? Got it. All right, you're gonna have a seat. Are you a defendant? What's your last name?
Hey, did we did an exam on Casey McKenzie? Did we ever get a copy of that, you know?
No.
I don't know if we did it be in the file. The prelim?
Yeah.
Yeah, it's in there.
Okay.
Mr. Milaro,
if it is,
I have.
can you send it to
Mr.
Brian?
Milaro, you're not muted? Okay, Ms. Fonseca, why don't you step up? We'll get rid of, not get rid of you, but take care of you on your way today. All right. All right, Mr. Milaro, when you're ready, I have Ms. Fonseca here. Oh, Mr. Malaro, in the matter of the people of the state of Michigan versus Sarah Fonseca, file number 24-22038FH. I have Salvatore Malaro appearing on behalf of Ms. Fonseca and Isaac Sneed appearing on behalf of the people. This is the date time set for pretrial. We've had quite a few. So, Mr. Malaro, how do you want to proceed today?
Your Honor, I'm going to ask for a brief adjournment. I did speak to Mr. Sneed yesterday. I think the matter can be resolved. I just need to talk to Ms. Fonseca about it.
All right, so I'm going to set this over to May 28th at 8:30 in the morning. We'll do the notice of hearing, Ms. Adams, so I can serve Ms. Fonseca. So May 28th at 8:30 in the morning. Today, call and schedule an appointment to meet with Mr. Malaro so he can discuss the plea offer with you. And then Mr. Malaro, I always appreciate if people sneak them in for a plea on a day, not a Wednesday. So
Understood.
thank you. Yep,
Thank
so
you.
have a seat right behind you and we'll get you a notice, okay? Okay, Ryan Fry is back. I have Ms. Scivoletto. Ms. Scivoletto, do you recognize that name?
I think it's Judge Olsaver's case. Because Jonathan's and Judge Olsaver just wanted.
Ms. Scivoletto, do you want to unmute your device? I think you might be in the wrong court.
Okay, I will try to jump over and hopefully I didn't miss it.
Yeah, or it's on YouTube if you look for Judge Olsaver.
Okay, perfect. Thank you.
Thank you. But I'll let you know. I'm crashing. All right. So today, it was last week. Does she want to move it? She's just want to move it. I see her if we can do that. I'm all right. So, okay. So Ms. Rembert, Mr. Malaro, I have Ms. Rembert. This is in the matter of the people of the state of Michigan versus Malika Rembert, file number 24-21966FH. I have Salvatore Malaro appearing on behalf of Ms. Rembert, and who do I have? Mr. Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference. So, Mr. Malaro, how would you like to proceed? I can't hear you. I'm so sorry.
Can you hear me now, Judge?
Yeah, I can hear you now. I think your mic just has to kick on. I don't know. So silly.
Judge, if the court recalls, Ms. Rembert was not in court last week and we adjourned it to this week. I'm glad to see she's here. I need to meet with her so we can get this matter resolved. So I'd ask to adjourn it briefly.
All right. So Ms. Rembert, I'm going to set this out to May 28th at 8:30 in the morning. Write that date down, May 28th at 8:30 in the morning, same Zoom number. And reach out and have a discussion with Mr. Malaro before that date, okay?
Okay, thank you.
All right, thank you, Ms. Rembert. All right,
Thank
Mr.
you,
Fry, with regard to Mr. McKenzie, what would you like to do?
Your Honor, we would be asking that this be set for trial.
All right, all right, so he has one file. How many days do you think for trial?
I would say 2 days, maybe a third.
2 days, maybe a third, okay. And All right, and let's see. Mercy. I'm gonna put 3 days. Does that include jury deliberations, Mr. McCready?
Yes.
Okay. So I'm gonna put 3 days. Mr. McKenzie, when is what is your like out date?
My out date's October 26th of this year.
So I could do September 23rd, Mr. McCready.
I'm in trial the entire month of September. And that goes through the second week in October, the trial that I'm in.
All right. Does that include September 2nd? Well, I already set, did I set one already September 2nd? Let's see. How about September 2nd? Are you already started in that trial?
That's the day, that's the start date for it, yes.
You did, Mr. Simmons.
August 26th. Did I set one that day?
No.
August 26th.
That's fine.
Mr. Fry?
That would work for me.
All right, that gives us 3 days, but no more. Okay. So I'm going to set this for August 26th. It starts at 9 a.m. And I'm going to set a final pretrial for August 6th at 8:30 in the morning. That'll be the motion deadline. And then I will require jury instructions, voir dire questions to be provided to the court by July 30th. All right, so I filled out a scheduling order. We'll get a copy of that out. And obviously, if there's a resolution reached, bring them in. Has there been a plea offer made in this file?
Yes, Your Honor.
What is it?
He would plead to count 1 home invasion first degree and count 4 felony firearm with the sentence agreement of the 2 years flat on the felony firearm consecutive to a 72-month sentence on the home invasion that would be concurrent with the sentence he's currently serving, which that's a 3-year sentence. So essentially would cut that 72 months in half.
All right, so Mr. McKenzie, the plea offer is plead to count 1 home invasion first degree. That is a 20-year felony, but there's a killabrew to an agreement of 72 months with count 4, which is a felony firearm. That is a mandatory 2 years that would run consecutive. So it would be 24 months and then you would serve the 72, but they're agreeing that it would run concurrent with your current sentence. And that would allow for some credit as well, Mr. McCready, or no?
Yes.
Yeah. So you would be getting credit since arraignment, correct, Mr. Fry?
That's my understanding of the offer, Your Honor.
All right, and then if you, and I don't know anything about the case, if you were to get convicted at trial, count 1, count 2, count 3 would carry a maximum penalty of up to life in prison. Do you understand that, Mr. McKenzie?
Yes, I do.
Do you have any questions about that plea offer?
No, I do not.
Okay, all right, and all right, so I filled out the scheduling order for trial. If there's anything you need, let me know. Mr. Fry, if a resolution is reached, obviously let us know. We will get Mr. McKenzie here sooner than that, all right?
Will do, thank you, Your Honor.
All right, thank you, Mr. McKenzie. You have a good day.
Yeah, thank you.
Thank you. Thanks for bearing with us this morning. All right, Mr. Orozco, let's see what I got left. Sam. I don't think I have anything else for Mr. Fry. So, Mr. Rasco, let me find your attorney.
That's me, Your Honor.
Oh, Mr. Glazier, let me grab your file, Mr. Rasco. So this is in the matter of the people of the state of Michigan versus Joel Jesus Rasco, file number 25-22129 FH and 25-22130 FH. I have John Glazier appearing on behalf of Mr. Rasco, and I think I already said this, Isaac Steen appearing on behalf of the people, maybe. I think I said that, but I have received 2 felony informations that have been amended, one for each file, which I'm looking at right now. Yep. All right. So I'm going to guess there's a plea offer on file number 25-2219 FH. So I see count 2 as an asterisk. So what is the plea offer, Mr. Glazier, on 25-22129? Is your client going to avail himself of a plea today?
I haven't, I'll have to speak with him, Your Honor.
Okay, so I'm going to open up a breakout room, and Mr. Rasco, I'm going to put you and your attorney into that breakout room. All right. Okay, go ahead and join that breakout room. I'm going to step off the bench for a moment. Is she okay? She's doing okay. No, I just did something on your last.
Please rise, start course now session. You see it.
All right, so Mr. Glazier, are you ready to proceed on Mr. Orozco?
Yes, Your Honor.
All right, how would you like to proceed today?
Your Honor, he's got two files, I believe, and he's gonna plead to a DV second on both files.
Is that correct? Plea offer, Mr. Steen?
Yes, it is, Your Honor.
All right, let me write that down. Okay. All right, so Mr. Orozco, you want to raise your right hand for me, please? do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. You want to speak up a little bit louder for me? Can you state your full name for the record?
Joel Jesus Orozco.
All right, so, hold on one second. Ooh. Right now, I don't have Sam. Oh, Sam Malaro. He needs to go to Judge.
Yes, Judge.
Can you go to Judge Olsavers? They got an out-of-county Zoom from a jail, and they are going to disconnect in a few minutes.
Oh, yep,
So do
yeah,
you
I
want to
can
go?
do that. Yep, I'll do it.
Okay, thank you. Can you check my phone? It's in my purse. Make sure nothing's wrong. All right. So Mr. Resco, you've heard the statement of your attorney and the prosecuting attorney. On each of these files, an amended information has been provided listing an added count 2 domestic violence second offense, which carries a maximum penalty of up to 1 year in jail. So Mr. Orozco, is it your intention to plead guilty on each file to count 2 domestic violence second offense?
Yes, ma'am.
All right, are you satisfied with Mr. Glazier as your attorney and the advice that he has given you?
Yes, ma'am.
Oh, I don't like my ringtone. I'm sorry. Okay. Do you understand the maximum penalty for this offense could be up to a year in jail?
Yes, ma'am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Glazier?
Yes, Your Honor.
Is that correct, Mr. Sneen?
Yes, thank you, Your Honor.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Orozco?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that as well?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right, on file number 25-22130FH, I'm sorry. How do you wish to plead to the charge that on or about? Oh, hold on, let me finish. I'm sorry. How do you wish to plead to the charge that on or about January 18 of 2025 in the city of Adrian in the county of Lenawee, that you did commit the offense listed in count 2, domestic violence second offense? Guilty or not guilty?
Guilty.
All right, Mr. Rasco, how do you wish to plead the charge in file number 25-22129FH that on or about January 10th of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense under count 2, domestic violence second offense? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to get you to plead guilty to this offense?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claim that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing or that it was not your own choice to enter the plea. Do you understand that?
Yes, ma'am.
Is prosecutor defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier?
No, Your Honor.
Mr. Sneen?
No, Your Honor.
Your attorney promised you any particular sentence or estimated what your sentence will be?
No, ma'am.
You understand? Okay. And is it your own choice to plead guilty on both of these files?
Yes, ma'am.
All right, so Mr. Rasco, we're dealing with two incidents a week apart from each other. So on file number 25-22130FH on January 18 of 2025, we're in the city of Adrian in the county of Lenawee.
Yes, ma'am.
And at that time, were you in contact with someone with the initials of KT? Was that your girlfriend?
Yep.
All right, and did you at any time push her, punch her, kick her, spit on her, push her hand away? Did you do anything that was assaultive?
Yes, ma'am.
What'd you do?
Huh?
What did you do on January 8th? On January, I guess we're on January 18th. Did you push her? Did you pinch her? What did you do to assault her?
Push her.
Okay. And then, are you satisfied on that file, Mr. Sneen?
I am, Judge. Thanks.
All right, and we'll move on to file number 25. That was file number 25-22130. So we'll move on to 25-22129FH. So this one's January 10th of 25, a week earlier from that last one. Were you also in the city of Adrian in the county of Lenawee?
Yes, ma'am.
And you were in the contact with KT as well, who was your girlfriend at the time. Is that correct?
Yes, ma'am.
And on that day you assaulted her. So did you push her, pull her, punch her, kick her? What did you do to assault her on that day?
Push her again.
Okay. All right. Mr. Sneed, are you satisfied?
Yes, we'll accept that plea. Thanks.
All right. Has court complied with MCR 6.302 B, C, and D? Mr. Glazier?
Yes, I have.
And Mr. Steen?
Yes, thank you.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor's office, the defendant, the defense attorney, or anyone acting in the interest of either of them. I'm going to refer this matter to the district court probation department for a pre-sentence investigation. Mr. Glazier, are you available June 12 at 8:15 in the morning for sentencing?
Yes, Your Honor.
All right, and Mr. Orozco, do you want to appear in person or via Zoom?
Zoom.
Zoom, okay. All right, Mr. Glazier will meet with you in advance of sentencing. Someone from district court will come and meet with you and do a pre-sentence report. We'll provide that to Mr. Glazier and he'll meet with you before sentencing day, and we will be truthful with them about your background, the events that occurred, and we'll see you back on June 12 at 8:15 in the morning via Zoom. So you're all set, Mr. Orozco. Thank you.
Ma'am, even though I'm seeing district probation, I'm gonna be in your court though?
Yep, so it's a misdemeanor plea, so I keep it for sentencing. And are you on probation upstairs anymore?
No.
Good. All right. Yep, I do the sentencing, not district court, okay?
All right.
Thank you. And Mr. Glazier, just to make sure it's on everybody's radar, May 1, starting on May 1, if defendants violate bond conditions or terms of agreement before sentencing, they will no longer have the right to withdraw a plea. Under Killebrew, there's been a change in the law that starts May 1. So we'll start changing. They have to, like, if they violate bond conditions or commit a new offense or violate a plea agreement, they won't have, I think, that automatic right to a plea withdrawal.
Okay.
So I know we sent an email out about it, so I just want to make sure it's on everybody's radar starting next week.
All right, thank you, Your Honor.
You're welcome. All right, you're all set, Mr. Orozco and Mr. Glazer. I don't think I have anything else with
No,
you.
that's all I have. Thank you, Your Honor.
All right, thank you. All right, Mr. Orozco, you're all set.
Thank you.
And Isaac, I think we sent that over to the prosecutor too. I'm not sure. We could probably resend it though.
Yeah, we got it, Judge.
Okay. I think it's what if they violate bond conditions, violate plea agreement conditions, or commit a new offense, even if there's a killer brewer Cobbs, they won't have the right to withdraw the plea. I thought that's what it basically was. So
Yeah.
okay, I have a couple left. I have Charity Smith. I don't have her, but I have Matthew Powers at 10:30, and then Heimerdinger. Ms. Adams, were we able to verify whether Jackson was going to produce her?
I have not reached out to him. I will, Judge.
So, all right, I do have a PPO file I received from Judge Olsaver. So, is it Zaret? You want to come sit here, please? And then Mr. Evans, you'll come sit there. This is in the matter of Zaret Evans versus Dustin Evans, file number 25-52438 PP. This is previously a Judge Olsaver file, and he is disqualifying. So we have been brought this file this morning. So, and how do you pronounce your first name?
Zaret.
Zaret?
Yes.
All right, I'm gonna put that in here. Just make sure you speak loudly for us. So can both of you raise your right hands for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Ms. Evans?
Yes,
And Mr. Evans? You're gonna have to, I know you're soft spoken, but you gotta speak loud for me, okay?
yes, Your Honor.
Okay, so this is a date and time set for a show cause. I show that on February 21, I actually signed a PPO in this case. I don't know why it was down in Judge Olsaver's file, but it was. And this personal protection order remains in effect to August 22nd of this year. I typically do that. Was a divorce filed as well?
Yes, Your Honor.
Okay, so I typically do that 6-month cooling off period because that's usually when the first pretrial, you must have minor children.
Yes, Your Honor.
Okay, so I set it out, and then Ms. Evans filed a motion to show cause for violation of the personal protection order back on April 18th of 2025. And she stated that the respondent violated the PPO. On April 18th, you left your residence at military time, is that 2:11 in the morning?
Yes, Your Honor.
Okay, to head to your work site for your Marine Corps Martial Arts Program final training event. You left the children home with your mother. You made it there around 3:45 a.m. and at 3:57, you said he called you and texted you, fuck the legal stuff, right after not answering his phone call. He then decided to go to the house and saw that your car wasn't home. He accused you of leaving the children alone and said he's looking for our son Noah. That at 4:20 a.m. he broke into the house through the living room door. My mother was upstairs. She didn't hear anything. And he entered the house and was with your son Noah. He texted you. You had the police dispatched. You did call him to see if he took Noah, but Noah answered the phone. And then he was at your house on the phone. So let me ask you this. The divorce case was filed. Did you have, okay. So he's continued to text you and to call you. Is that correct?
Yes, Your Honor.
Speak up for me.
Yes, Your Honor.
All right. And were charges filed against him for breaking and entering? Yes, Your Honor. So he's facing pending felony charges?
I believe so. Your Honor.
Okay. And have you received notice of any court dates on that?
Not yet, Your Honor. I was told it would be about 2 weeks before.
Okay. So, Mr. Evans, part of that is I wanted to verify if there could in fact be pending criminal charges against you, because that does impact how I would advise you to proceed today. Do you understand that?
Yes, sir.
So, Mr. Evans, do you have a divorce attorney?
Yes, sir.
Who's your attorney?
It's Simpson.
Okay, and who's yours?
Matthew Raines.
Mr. Raines. Okay, two very well experienced attorneys. So, Mr. Evans, you potentially could have criminal charges stemming from this. So anything you say today on the record could be used against you. So I would advise you at this point, your best interest would be served by pleading not guilty. And are you going to retain Mr. Simpson on this violation of the PPO?
Yes.
All right. Do you know when your next divorce pretrial is?
August 20th.
Okay, so I'm gonna set this out for another date, but Mr. Evans, understand, if there is another violation or allegation of a violation of the PPO, I can give you up to 93 days in jail for every violation.
Yes, sir.
So you will be sitting in jail for a long time, especially if there are pending charges. You may have a bond on that where you have to post to get out. Do you understand that? All right, so this is very, very serious. Okay, so those are the allegations against you. I'll enter a plea of not guilty on your behalf. I don't want you calling her. I don't want you driving by the house. I don't want you calling your mother. I don't want you to have any contact with your children unless it's through the divorce file. Do you understand that?
Just can I ask a question? We use the OFW app. And
App close?
It's the Only Family Wizard.
Yeah.
That's how I call the kids every day. Can I still do that? Because there's nothing in any of the files that's like I'm not supposed to see my kids or talk to them.
I
haven't been able to see them this whole time. So.
Yeah. Well, you know, you're saying things like the allegation and the text messages that I will walk inside and get the kids, but the legal stuff, I'm just asking you to answer. My concern is you're not going to honor the court's orders.
I will.
Because you're looking at a felony. Do you understand that? So I would advise that you call your attorney today and you call your attorney today. But I don't want at this time any contact even through our family wizard. So if there's going to be contact with the children, it's going to be some other way and your attorneys can make arrangements. But based on these violations, I don't even think our family wizard is appropriate at this time. Okay, because these are major serious violations of the PPO, especially with pending felony cases. So you are in a place where you gotta rein whatever is in just so you don't lose everything. All right. Okay, so Ms. Adams, I would like to set this out to June 4 at my book. I think I gave you the book back. June 4 at 8 a.m. And ma'am, you can appear via Zoom. Do you understand that? You don't have to come in person. Do you have Zoom instructions?
I did not.
All right, Ms. Adams, I'm gonna need a notice of hearing for both parties and Zoom instructions for the petitioner in this file.
Okay.
All right, and you'll have to come in person, okay? So we're gonna set this over to June 4 at 8:30 in the morning. And you're gonna stay right here, actually, and then you're gonna stay right there for now. And we're gonna get you those notice of hearings. And then I'm gonna allow you to leave first, ma'am. And then I'm gonna have you wait 10 minutes, okay? But, I mean, you already have a violation of this PPO.
When this day one, when it first happened.
Yeah. You're hiring Mr. Simpson on this?
Yes, ma'am. So he put in paperwork, to be able to see my children. I just don't know.
No, on this PPO violation.
Oh, yes. Ma'am. So I hired him for the divorce and then for the PPO itself. He said 2 different cases. So I had him.
So, but he's not here today?
Not for the violation. Because I just hired him for the, try to get it reduced so I could see the children. And I just got this on Monday.
Are you hiring him on this?
Yes.
All right, Miss Adams, I'm gonna take that back. I want a sooner date. Can you connect with Mr. Stimson's office to see if he's available May 14th?
Okay.
Hold on. Your Honor,
Mr. Malaro?
I have a William Feebig on my schedule. Is that on your docket? I didn't see it.
Say it again.
A William Feebig is on my schedule, but I don't know if that's on your docket or not.
Did he say Fleabag?
I can't understand.
Feebig.
I have William Powers, Christina Smith, Heimerdinger. I have a Charity Smith with you.
Yep, that's mine.
But
All
who
right.
did you say?
William Feebig.
Fleabag?
No, Feebig.
Spell it?
Fiebig.
No, I don't have that one.
All right, I'll have to look into it.
So it sounds like Fleabag.
That's not what I said. All right. I think Miss Smith usually does Zoom, Judge.
Well, she didn't today. Do you want to try to reach out to her?
I'll send her a message if you could give me a minute, Judge.
Yep, not a problem.
Judge,
Yeah.
Mr. Stimson is not available. We did work out May 22nd at 11:30 a.m.
All right, May 22nd at 11:30 a.m. So Miss Adams, could I get a notice of hearing for both and Zoom instructions for Miss Evans? I'm also gonna have Mr. Coast. You're employed.
Yes, ma'am.
My bailiff's gonna watch you for a minute. Don't go anywhere, all right? Be right back.
Man, just hang on. I don't know if the judge needs you to or not.
Oh,
Just you know.
first I'll check. Judge.
Joey, did you get that this afternoon's canceled?
Did I get one?
Did they tell you this afternoon's canceled?
Yes.
Okay.
Oh, great. Yes.
Sure. Yeah.
1 week. It's like a vacation.
Yeah.
All right, so we are back on the record in the matter of Evans v. Evans. I took a brief moment because I wanted to do something that I typically do here in Lenawee County. So I was able to check in with the esteemed Judge Joseph Costello of Monroe, who is retired. So, Mr. Evans, I am going to enter a not guilty plea on this today, but as a condition of bond, I am ordering a GPS tether under 6.108. Behind you is Darren Coast, who is my pretrial services coordinator. And he is going to work today to make arrangements with you on a GPS tether. So, sir, the requirements, you are not to be within, I would say, a 5-block radius of where the house is or for employment. Do you understand that? And Mr. Coast is probably going to ask you where you're employed. Okay. And I'm going to, at this time, order that there not be any more contact on our family wizard pending all of this. And Ms. Evans, do you have any questions?
No, Your Honor.
Please speak up.
No, Your Honor.
Okay. So, Ms. Evans, I'm gonna let you leave. Mr. Coast will walk out the hallway with you and get your employment information, your house address, and just verify what's on the paperwork, and then you leave. And then he's gonna meet with you, Mr. Evans, all right?
Yes, Your
Okay, thank you. And you've got your notice of hearing and Zoom instructions, okay? All right.
Mr. Evans, I'll share a seat right there, and I'll come back.
Ms. Evans, come this way. Just stay right there. Okay, and now you go to Mr. Coast, go to him. All right, and Miss Adams, I'll help you with some language on that, all right? Okay. So I've got Matthew Murphy, Salvatore Malaro, and all right. In the matter of people of the state of Michigan versus Jamie Heimerdinger, we don't have her today. So I think that I will set it out to May 28th for another pretrial, and we'll try to get her from Jackson County Jail. It's May 28th at 8:30 in the morning. Mr. Malaro, Charity Smith. Hi, this is Judge Anzalone. I am ready on William Powers.
Okay, I'll get him rolled in.
All right, thank you.
Yeah, thanks.
Now I got Kayla Walden. Miss Walsh, Kayla Walden just came in. Miss Adams, do we still have Kayla Walden's file?
I have it.
Okay. All right, hold on, Miss Walden. Let me grab your file, okay?
Okay.
So on this one, I ordered a month condition with GPS tether, not to be within 5 blocks of the home. Is that all right?
Yep. And family wizard.
And no contact on our family wizard. Good call. You want a Roscoe too? Thank you. All right, so Miss Walden, this is in the matter of the people of the state of Michigan versus Kayla Ray Walden, file number 25-221-01FH. Ms. Walden, this is the date time set for request and summons for probation violation. I'm going to set aside the bench warrant because you did appear. So I'm assuming, did Ms. Walsh get a hold of you?
No, today I talked to Tom Moore today. So
Okay.
Yeah, I've been in treatment since last Thursday, but I just kept forgetting to call probation, you know what I mean, and let them know I was here. Every time I would remember, it would just be, past 5 o'clock every time. So
Okay, so Miss Walden, okay, so which program are you in?
I'm at Dawn Farms right now. I'm at the farm. So I
You're-
was
you're
at
at-
Sarah. I was at the downtown location, but then yesterday they brought me to the farm.
All right, and you will sign so that we can release that information to our probation department?
Yeah.
Okay, so you're gonna sign whatever so that they can this is a Miss Teskey file now. So you'll sign to grant permission so that Miss Teskey can call and verify that you're there?
Yeah. However, I need to do that or whatever. I'll talk to them and see whatever I have to sign or whatever to make sure that she can. So I think I put Tom's name down as I put Tom and Jennifer Walsh. But he told me that it's Sarah Teskey now that would be taking over.
Okay, all right, so add her to that, and, all
I will.
right, so I'm gonna adjourn this out to May 14th to verify that you're there, all right? Because obviously
Okay.
I want you to get treatment. The violation of probation is that you failed to report to probation as required on April 15th of 25 or anytime thereafter. And so that is a technical violation. The maximum penalty, obviously your probation on a possession of methamphetamine, which is a 10-year felony, so you could be facing up to 10 years in prison. So I'm gonna enter a plea of not guilty today. I'm gonna set this over to May 14 at 8:30. So write that down, May 14 at 8:30, same Zoom number. And then I need you to sign off. So Ms. Walsh, Mr. Moore, Ms. Teskey can contact and verify that you're there. If you're not there though, I'm gonna issue a bench warrant, all right?
Okay.
I'm also gonna amend your terms of probation that you comply with all the terms of Dawn Farms and not, and to enter and complete it, all right?
Okay. Which actually the reason why I called today, why I was calling Tom, which I would have to call Sarah, he said, because he's not handling it anymore. But I called because I wanted to switch from the farm to somewhere else that is like a 30-day program instead of doing 90 days.
So
You know what I'm
here's the
saying?
deal.
I wanted
Here's
to
the
leave
deal.
from
Hold
here
on,
straight-
Kayla. I'm gonna leave that to the discretion of whoever your probation officer is now. So don't be leaving that program until you talk to Sarah.
Yep.
And if Sarah wants to work something out, then let Sarah, but you gotta do what Sarah says, all right?
Yeah, I'm not gonna leave treatment
Do not
unless
leave
I'm
there
going.
until
Yep.
Sarah Teskey arranges for it or authorizes it, okay?
Right. So I'm hoping she'll have me go from here straight to another treatment center. You know what I mean? But so I'll
We'll
just
see what
she's-
happens.
Yeah.
Work with Sarah, okay?
Right. Okay.
Okay. All right. So, you're able to call Sarah, are you not?
Yeah, I tried calling her, but I didn't get no answer. But
She's not in today, Miss Walden, so just leave a message, one message.
do you
She
want-
doesn't need, don't call her repeatedly, okay?
Okay.
Okay. Do you need a breakout room with her, Miss Walsh? Nope. Or no? All right. So Miss Walden, I will see you back on May 14 May 14 at 8:30 in the morning. All right.
Okay, and then the same Zoom number, right?
Yep, same Zoom number. And then you call, like you said, leave a message if you haven't already for Ms. Teskey and only leave one, and then authorize her to verify you're there, okay?
Okay, I will.
All right, thank you.
Yep.
Thanks, bye-bye.
Bye.
Okay. All right, Ms. Mr. Malaro, hold on 1 second. All right, Mr. Malaro, were you able to reach Charity Smith?
Your Honor, I sent her a letter I sent her a message and I don't know if she hasn't responded yet. So I was hoping she would just log in.
Well, she is not.
She's very good about maintaining contact with me.
So she has not appeared. I can adjourn it out one time. See if
I would
she'll show up.
appreciate that. Yeah, I would appreciate if you'd be that kind, Judge.
Let me see. I don't think the file's not very thick, so I don't think we have a notice. So let's see. I don't show any contempt of courts for failure to appear, so it looks like she's appeared. So I will set this out to May 21 at 8:30 in the morning, and you'll do the step in order to adjourn.
I will, Your Honor.
All right, so with that being said, I do believe we have completed our pretrial and arraignment docket, and that leaves us with Mr. Murphy and his motion. I don't think I had anything else with you, Mr. Malaro.
I guess not. Thank you, Judge.
All right, thank you. Mr. Murphy, you are in your office. Good to see. All right, and who's the prosecutor?
I'm sorry, Your Honor, my volume was turned down. Could I have a breakout, Mr. Powers? And this is Mrs. McClure's. I know that she would, obviously she had filed an answer, and I expect her to be here, so we're fine with waiting.
She's here. She just walked in.
Oh, okay.
Okay, so you want a breakout room with your client?
If I could, please.
Yeah, so in the matter of the people of the state of Michigan versus William Mitchell Powers, file number 24-22033FC. I have Phoebe McClure appearing on behalf of people and Matthew Murphy appearing on behalf of the defendant. So, Mr. Murphy, I am going to assign you and your client to a breakout room. Go ahead and click join on that breakout room. Okay, so did you guys file a response?
Yes.
You have an extra copy, or can you email it to me?
I can email it to you.
I don't think Mr. Murphy didn't get one either.
I sent them all on Monday.
Wow, it's only Wednesday. Come on. Snail mail.
Girl, I emailed because I was emailing it to Sierra. And I emailed it to Mr. Murphy and Sierra, and then I told Kim I needed it in your file for today.
Wow.
So
I created chaos by getting sick, so.
no, I hate you not getting them on time. Is that it?
Got it. Thank you.
I'm trying to find a copy that I can get to Matt.
Judge, can I ask you a question?
Sure.
So that plea with, the embezzlement case
Yeah.
and the plea for 5 years probation.
Say it
There's-
again.
That there's part of that plea is for 5 years probation.
Yeah, I know. I heard that.
We're not allowed to do that anymore because of that public act. That's only
I know.
for sex offenders and aggravated stalking. So
I know.
Is it-
We'll bring that up at sentencing. I thought about that later because we had a plea missing for what she's talking about as Caitlin Weiss Roberson pled to an embezzlement charge. We can't give 5 years probation anymore.
Oh,
So the prosecutor was Mr. Margolis and McCready maybe.
it was
Huh?
Jackie.
Jackie. So can you send me that statute? So I can
Yes.
forward it on to them?
Yep.
what is it says you can't get 5 years probation.
They passed something through and it's, unless it's a certain listed offense, you can't get
Oh,
5 years probation.
Okay.
Because we used to in the old days get 5 years probation on everything.
This is
And,
the same, this stems from the same thing that we keep going over, that we can't give more than 15 days for the first violation. So, because
Yeah.
the no upfront jails come a lot from, I think, people thinking we're allowed to give a lot more violations and we're not. So this is
I
like,
thought, Ms. Walsh, I thought we talked about it and that you could, if it was detailed in the plea, a certain amount that they would get if they violate.
no, but there's.
I thought we talked about that.
So in technical, we can only give up to so many days and no more. That's why we release them now. If they
I know, I just thought we talked about it and that you had told me of a way to word it and I thought that's how we were doing it. But
Well, this is another day. We got Mr. Powers back.
Exactly.
So, all right, Mr. Murphy, you're back on the record and, okay, so I have a post-it here, that a plea offer was made previously to plead guilty to count 1 and count 3. Is that correct?
That is correct.
And then count 2 would be dismissed. And, was there a guideline term to that Killebrew agreement or that plea agreement or anything?
We hadn't talked about it, no.
Okay, I just was making sure.
No, we didn't talk about a sentence agreement at all.
Okay, so Mr. Murphy, the people did file on April 29. Yesterday, it looked like it got filed, but it was emailed previous to that, a response. Have you received that now? And would you like to take a
Yes.
minute to?
Yes, Your Honor, I received that and reviewed that. Thank you for asking.
Okay, all right, so, okay, so Mr. Murphy, you can proceed on your motion.
Yes, Your Honor, I just wanted to clarify for the court's own information. Yes, there was offer relayed. Mr. Powers, he's pretty vehement about his innocence in this matter. Obviously, the prosecutors relayed information. I've talked to my client about that. But I just wanted to clarify for the court at this time, and it is our intention to go to trial ultimately on it, just a matter of, if we can get to that trial date. Now, I did file the motion. I'm not going to, repeat my motion much. I did cite pretty much most of it was a lot of law that the court's well aware of. That was just for my own benefit to make sure I clarified it with myself. Now, obviously, with Mr. Powers, as we had said, and it's pretty clear, the court can do no bond. The court has, the Michigan Supreme Court is pretty clear that the trial court, Your Honor, has extreme discretion in regards to this. And again, as we noted, it is a possibility of no bond here, but Mr. Powers is not a case that would call for no bond, Your Honor. I think when you look at the situation, he doesn't have a prior record that would, I think there's, as I had mentioned, there's maybe 2 prior cases, nothing of this nature. He doesn't have a prior record, anything like this charge. I believe at the planning examination, the complaining witness had testified that this had never come up before, behavior like this hadn't occurred before. So I do believe, again, as I cited in my motion, that a personal recognizance bond would be appropriate, and that there could be conditions placed upon that Your Honor would be able to put on to alleviate any concerns the court or the people would have. I don't believe Mr. Powers is a flight risk. He's lived in Lenawee County for going on 9 years prior to being incarcerated. Before that, He lived in Monroe County. Furthest he lived from Lenawee County at all was Wayne County. He doesn't have an extensive family outside of the state, outside of the country, again, even outside of the lower southeast Michigan region. He doesn't have the funds or capability to flee. As I believe I've argued before, in regards to this matter, he has a charge that will command a nationwide warrant upon pickup. If anything was to happen, he's well aware of that. He knows he couldn't really flee to any other country, obviously. He wants to stay, he wants to fight this charge, as I had said in the motion, as he had said repeatedly. And I believe that because of that, he's not a flight risk. He wants to clear his name. He wants to have his day in court, or days in court. And as such, I believe that, again, conditions can be in place that would alleviate the concern the court would have. I'm not going to suggest to the court what those would be. We're trying to, I think the court has a pretty good idea of what the court would want to do. Mr. Powers would be able to put on a tether if need be in house arrest if need be. Any conditions the court would impose, he would abide by if the court would be willing to allow him a personal recognizance bond. So we just wanted to, again, ask the court to reconsider based upon the information we've given to the court. We do believe it's appropriate for Mr. Powers to have a personal recognizance bond. Thank you.
Right, the court will also note that there's a preliminary exam transcript that was held in this matter on October 30th of 24. Is that correct, Mr. Murphy?
Yes, Your Honor.
And I did review that. So, all right, Ms. McClure.
For the most part, I want to rely on my brief, but obviously the people having a pretty strong position that bond is appropriate as set in this case. One thing I did not put in my brief is that we don't believe there's been any, and I don't even know that Mr. Murphy argued it, but I do want to make the point. There's not been any long delay in this case from when it was charged to us getting to trial now. And I think that goes to show that, one, we're really moving forward on this, and we're getting through this, and there's not been any big, it's not showing of any due process concerns for the defendant at this time. He's not had any prolonged period of incarceration that, again, isn't justified by the bond that is set. But one thing that is worrisome to the people that's kind of come up is that in Mr. Murphy's motion, he indicates his client has not ever reviewed his discovery. And I think that is a concern, because obviously we are approaching trial in this case, and he's rejected the plea offer as of now without ever fully reviewing his discovery. And I think that's important in this case, is the people know in their brief, and the only reason I put in my brief some of the people's evidence that we anticipate, excuse me, I can't think of the word. We anticipate entering at trial is does show the strong likelihood of conviction in this case, and the sufficiency of the people's evidence, which is always relevant, especially in these cases when you're talking about bond. And of those, the main one being that since this was charged and while we were pending, this case was pending lab results when it was charged, and since then those lab results have come in. They've been provided to, obviously, Mr. Murphy. He's indicated he's gone over them with this client, but he also put in his motion that he has not gone over discovery with this client, and I think that's a problem. But the biggest one is the lab report that does show the presence of this defendant's DNA on the victim's vagina. There's not another word for it. And I think given the accusations in this case, or the allegations in this case, and the charges, that strongly points to his guilt as to counts 1 and or count 2 in this case that the jury would consider. So I would hope that, one, the court would maintain the bond as is, given the sufficiency of the evidence and the allegations, and 2, that Mr. Murphy does review this thoroughly with his client, review this case thoroughly with his client at the jail prior to trial, so that he can make an educated choice on whether he really wants to go forward with trial or take advantage of the plea offer. He's facing his guidelines on the CSC first are just under 15 years, but if convicted at trial of all 3 counts, he's facing at least 2 consecutive sentences, discretionary consecutive sentences, whereas the plea offer would take that away, and he would just have the possibility of a CSC first and a CSC second, non-consecutive. So I just wanted to point that out for the defendant's benefit, but also just urge this court, based on my motion and everything presented, that bond do remain as is. Thank you.
All right, Mr. Murphy.
I just wanted to clarify for the court. I have reviewed discovery with my client to what extent I can when I brought over it to the jail and had him review it. As I was expressing in the motion, we don't leave the documents and the material there, which obviously I was trying to explain that Mr. Powers would have a lot more opportunity to review it further. Obviously, between now and trial, there's going to be a lot more. If he's still in custody, there'll be more appointments, more dates going over there. One of the issues that we have is we don't have internet over there. So when we try to view videos with people over there, it becomes a problem with bringing our computer. Anyway, that's, again, I just wanted to clarify for the court. I have reviewed that with Mr. Powers. Now, one of the considerations the court is to consider is the likelihood of conviction evidence presented. At this point, we have testimony from the complaining witness and DNA evidence that, again, that's left up to an expert and the trier of fact to determine what that evidence points to. Given the fact that their family members lived together for quite a while, presence of DNA can be explained through multiple different ways. Mr. Powers, I believe I've discussed things with him, and I would say, Mr. Powers, you believe that at this point you've been adequately informed as to the discovery that's presented against you, or
Yes,
do you feel? Okay, I just wanted to clarify that, Your Honor. But again, my anticipation would be.
Mr. Murphy, hold on. Mr. Powers, so Mr. Murphy asked a question. You've had opportunity with Mr. Murphy to review all the discovery and so forth. Is that correct?
Yes, Your Honor.
All right. And at this point, you're satisfied with Mr. Murphy as your attorney and the advice he's given you?
Completely, Your Honor.
All right. Okay. Now, Mr. Murphy.
I think that was it, Your Honor. Thank you.
All right. So, Mr. Murphy, the county should provide a hotspot on your phone so that you can connect to internet on your laptop. But
we're not allowed to bring phones.
That may be something you need to call about, or an iPad with that. But the court can, of course, schedule an in-person meeting here to accommodate that. So if you ever need an hour or two to prepare or anything, I can set that up here and have him transported to here, and you guys can meet in a room here where there is internet access. So the court will always accommodate you in that way. All right, anything else on your motion, Mr. Murphy?
I don't think there's anything more I wanted to add. Mr. Powers, anything you wanted to add if the court would allow?
We don't.
Not at this moment.
Okay.
Sorry.
Okay. Okay, so in this case, Mr. Powers is charged with, in count one, criminal sexual conduct, first degree, with fingers in vagina with a child who is at least 13 but less than 16, and members of the same household, and that carries a maximum penalty of life, mandatory lifetime electronic monitoring, and the availability of a consecutive sentence under MCL sub 50.520B3. Is also charged in count two with criminal sexual conduct, first degree, tongue and fingers in vagina with a child who is at least 13 but less than 16, and members of the same household. Again, life with mandatory lifetime electronic monitoring and a consecutive sentence availability on that one. Is charged in count three with criminal sexual conduct, second degree, which carries a maximum penalty of up to 15 years in prison, a tier 2 sex offender registration requirement. So a preliminary examination, it looks like, was held on October 30th of 2024. And the court did find at that time, by a preponderance of the evidence, I think was the standard at preliminary exam, that the defendant did in fact, for purposes of waiver of bind over, that the people had satisfied their requirements and bound Mr. Powers over. So at this time, it's correctly stated that the court can set bond at no bond. In this case, bond is set at $250,000. There are four factors the court must consider when determining bond: the amount of bail, the seriousness of the offense charged. I doubt there's any more serious crime than this, and murder. The protection of the public. There's some allegations by the prosecutor that before arrest, there was some attempt by Mr. powers to sway or suppress perhaps testimony against him. His prior criminal record, I don't have any information on that.
He does not have any.
He has no prior criminal record, and no determination of dangerousness other than the offense itself and the probability that the accused will appear at trial. The court does have substantial discretion in setting the amount of bail. Excessive amount of bail is defined as an amount that staggers the imagination under Carlisle versus Landon. 73 Supreme Court 1179 1953. The court finds that 250,000 is rather low, but not excessive for the nature of these charges. Our court did have a pretrial assessment done, and though he scored low because of his lack of prior record, the nature of the offense, pretrial assessment did indicate that incarceration was appropriate. Seriousness of the offense is concerning. Let's see. The court does find that the bond is proportional to the charges in this case and not excessive. As to his prior record, obviously he has no record that the court can consider in determining whether or not bond is appropriate, but that's not uncommon in these types of cases for the alleged offender to have no prior record. This did involve a minor child and a member of a household, and so I do feel that him remaining incarcerated is for the protection of the public. I am going to deny your request for a bond reduction. I think his bond is appropriate, if not a little low, but I'm going to leave it at $250,000. And as I said, Mr. Murphy, this court will make accommodations for you if necessary, to meet with him here at the courthouse if you need be for better access to internet. But I know, like, Mr. Malauulu has an iPad with internet to show videos, and so maybe you can get him to buy you one. All right, Mr. Murphy.
Thank you, Your Honors, for taking the time to consider.
All right, thank you. All right, thank you, Mr. Powers. We are set for trial, and I think there's a final, let me see here, final pre-trial. Let me see. We're in here. We do have one final pre-trial on June 11th at 8:30 in the morning, and then the trial is set for June 25. So we'll see you at that time. Thank you.
Your Honor, could I speak to Mr. Powers briefly before? I don't know if you had anything else going on. Thank you.
No, I don't have anything else going on. So hold on one second.
Thank you, Ms. McClure.
Close that.
Thank you, Your Honor. God bless you.
Thank you. Hold on, I'm going to put you in a breakout room with Mr. Murphy. All right, go ahead and join that breakout room.